Talk about justice and law. All right, so the first thing to note is it's complicated, right? You could do it by now. This is the basic lesson we get from Aristotle in class. If the question is, what's the relationship between justice and law? And your answer is, well, it's straightforward. The legal is the just, or the just is the legal. Both Aristotle and Aquinas are going to say, not so fast. There's a problem here that we need to take seriously. And it's expressed in different ways in the different readings, but all four of these readings are law of fiber, which is included, are after this basic problem of the relationship between law and justice. So we'll begin with Aristotle's Ethics. I'm going to give you some sort of general remarks on each of these readings as we get through, and point out the ways, the complications, the problems that we need to grapple with. And then we're going to open it up for a broader discussion. This is a relatively small group. You're all excellent students, so I'm not going to impose Robert's rules or anything on us. I want it to be a relatively free-flowing conversation. If we get to the place where there's a lot of traffic jams, I might something called the Liberty Fund protocol, where there's a queue and then you keep people in the queue. I don't think we're going to need it. Okay, so if we look at Aristotle, what's he saying? Well, Aristotle, remember, is interested in virtue. That's the background. Aristotle's Ethics is all about virtue, about the good life, a life well lived, a life worthy of being lived. And one of the virtues that Aristotle is interested in is the virtue of justice. And Aristotle tells us in Book 5 that there's a problem here, complication here, because justice can be, you could be talking about political justice, you could be talking about distribution of opportunities and the community, we could be talking about the remedy right of wrongs. So even within political justice, we have to distinguish between that which is we today call distributive versus that which we today call community. Proportional justice, there's justice of equality between persons. There's political justice, and then there's this individual virtue, this personal virtue known as justice. So the first complication is if we're talking about political justice, what is owed to people as members of the community, by the community, what they owe to the community, or are we talking about the personal virtue of justice? What is just as between citizens? Then, in part 7 of Book 1, where we live today, Aristotle says, even if we limit ourselves to the latter, if we just focus on that which is just as between citizens, we find that there are two parts of justice. And these two parts come apart from each other in interesting ways. There's natural justice, and there's conventional justice. It's sometimes called legal justice. Sometimes it's translated as legal justice, sometimes it's conventional. Basic idea of natural justice, he says, it has the same validity everywhere. It does not depend on our accepting or rejecting. So natural justice is going to be the same in Athens as it is in Thebes, as it is in Rome, as it is in London, as it is in Boston, as it is in Montgomery. And it's going to, what is just is not going to be contingent upon our acceptance of the proposition that such and such is just. However we define power. Whether we define power as assent by some institutional customs to the common law, or by majority rule, or representative majority rules in legislation, or by those things that we, the political community, have placed beyond the competence of legislative power, so the Constitution. However we define power, those are all aspects not of natural justice, but of conventional justice. or legal justice. It's not the same thing. Not every political community has jury trials. That does not mean that the French lack natural justice. What they lack is the particular conventional justice settled upon in the English tradition, inherited by the Americans. Unlike English, we would not do that which is conventional, at the outset, may be determined in this way or that way indifferent, but which, when once determined, is no longer indifferent. So at the outset, we might have said, look, it's a requirement of natural justice that accused have benefit of some procedures or process by which their guilt or innocence is adjudicated. Now, by our conventions, that's done in a jury trial. Now, before we settled on the jury trial, 1,100 years ago, the natural requirements of due process could have been specified or settled in any number of different ways. That's natural justice. As to the particular mechanism or procedure by which we adjudicate disputes, criminal or civil, the natural justice is more or less indifferent. But we have decided to settle by jury trial. That's conventional justice. And once we've settled that this is the way we do due process, jury trials, Aristotles says that's no longer a matter of indifference. It's now settled. It's a matter of justice. But it's a matter of conventional justice, not natural justice. Now he says, there are people who think that what is just is always conventional. It's the person to know here is 2,300 years ago, they were legal positivists. Right? John Allison and Jeremy Beckman learned that in the video back. So there are people who think that what is just is always conventional. How do they think that? Because that which is natural is invariable. It has the same validity everywhere as fire burns here in Persia, while that which is just is seen to be not invariable. We see a wide variety of specifications of justice when we travel from Greece to Persia to Turkey to Gaul. Right? So people infer from the fact of disagreement that there must not be such a thing as natural justice. People disagree about what's just. And so it can't be the case that justice is natural. It has to all be conventional. Aristotle denies that that's true. He says it's true in a way, but not true in a different way. And the way in which it's true is that much of what is naturally just requires further specification in our conventions. We'll talk more about this, but natural justice sometimes gives us concrete answers. A lot of the time it doesn't. What due process is just is a rather abstract, open-ended question, which is in a sense indifferent. But that there must be due process is not. It is always just to afford some sort of procedure for adjudicating guilt or innocence. What kind of procedure is a matter of indifference until it's settled by our convention. So if we skip down a bit, he says the terms just and lawful in each of their several senses and stand for universal notions which embrace a number of particulars. The acts are many, but the notion is one, for it is applied to all alike. So we have some general principles of natural justice. Think about the sectarianism in property. Always use your property so as not to injure that of another. How do we specify this principle in conventional justice, where we have two mutually incompatible land uses? For example, a brick kiln and a residence. It is the case, we just think about this in sort of morally neutral terms. If we go along with the positivists for the sake of argument, so let's all be positivists. Let's all be line coasters or coasts. Right? it is the case that if we shut down the brick kiln to save the residents from the vibrations and the smoke and the dust and everything, we're imposing some cost on the operators of the brick kiln. On the other hand, if we allow the brick kiln to continue to operate, we're imposing some cost on the homeowners. So if we're trying to think of this in morally neutral terms, it looks like a bit of an impasse, doesn't it? Aristotle says, no, there are some principles of natural justice, which can get us partly right there. So one implication of this might be, some discussion, think about the coming to the nuisance rule. Right? We want to know something about who is there first. And most people, when they first encounter the coming to the nuisance rule, say, well, that just makes sense. Right? It makes sense that you can't move in next to the brick kiln and build a house and then complain about a brick kiln. That's a specification of natural justice. But what you're doing there is complaining about a cost that you voluntarily accepted by moving next to the brick kiln. Well, what about the moment before either of those land uses, before either the brick kiln owner or the residential owner have built? It's a matter of indifference whether this particular neighborhood is going to turn out to be industrial or residential. Maybe, maybe not. Let's suppose for a moment that that's the case. It's a matter of difference beforehand. Now we have a zoning ordinance. The zoning ordinance specifies in this particular zone only residential. Or in this particular zone, we're going to allow incompatible uses and see what happens. Or in this particular zone, only industrial. Now we have a conventional specification. That becomes the standard of justice going forward. Now, there's all sorts of interesting questions about what happens when the conventional specification is in tension with the natural justice requirements. Right? So this is where you get into the vested rights stuff. What happens if the brick kiln is already there, and then a residential neighborhood builds up around it? Like this is the Harbison versus City of Buffalo case. They all came to the nuisance. And then they all pressured the city council to change the zoning ordinance to make the cooperage unlawful as a matter of the zoning ordinance, conventional specification. Now, a lot of people have the moral intuition, that's unjust. What they mean by that is that violates natural justice. They weren't doing anything unlawful when the time to build the cooperage for the 50 years thereafter. Nobody complained of the nuisance. Okay. So, all of that is driving Book 5, Section 7, Paragraph 7, to the following conclusion. That which is unjust, we must notice, is different from an act of injustice, and that which is just from an act of injustice. For a thing is unjust either by nature or by ordinance. It can be unjust either by nature, that is universally and everywhere, or by the particular specification in this particular political community, by this particular convention, this particular side. Okay, so that's how Aristotle communicates the concept. Then we get to Aquinas. He's going to pick up on Aristotle's discussion in 5.7 in question 95, Article 2 of the Treatise on Law. So he's going to pick up where Aristotle leaves off. And he says, okay, so Aristotle taught us about this distinction between natural and legal justice, natural justice and conventional justice. But it raises some real problems. It raises additional problems, which Aristotle really didn't get into. And we need to think more carefully about it. So objection 1, it would seem that not every human law, now human law here corresponds roughly to legal and conventional justice. So by human law, Aquinas means roughly what Aristotle means by conventional justice or legal justice. The specifications laid down, or in Aquinas' terms, reasons that are promulgated by a Hindu historical community for the common good. So it seems that not every human law is derived from the natural law, which corresponds roughly to natural justice, that is universal And here he quotes Aristotle. So the philosopher says that the legal just is that which originally was a matter of indifference. But those things which arise from the natural law are not matters of indifference. Therefore, the enactments of human law are not derived from the natural law. They must be two completely different things. And you can read Aristotle that way, can't you? There's a reading of Aristotle that suggests that we're talking about two different realms here. And that they have no inherent connection to each other. And we'll see that when we get to those agreements and some positives. Furthermore, objection 2, positive law, another term for human law, another term for conventional justice, is contrasted with natural law, as stated by Isidore and the philosopher, back to the mentioned at this 7. Objection 3. Further, the law of nature is the same for all, since the philosopher says, 7, that the naturally just is that which is equally valid everywhere. If therefore human laws were derived from the natural law, we should expect to find that they were the same everywhere. That's clearly false. The French don't have jury trial. The English do. And so a lot of people refer from this that natural justice just has nothing to do with legal justice. We're talking about two different domains. I answered that. And that, his first articulation, and our answer to that is back to Augustine in the natural law thesis, that if at any point human law deflection of the law of nature is no longer a law, but a perversion of the law, not as sometimes translated no law at all. That would be a contradiction. Sometimes an unjust law is no law at all. It's the translation you get. It's a bad translation. It's also illogical. Okay, but here's how Aquinas explains all this. But it must be noted that something may be derived from the natural law in two different ways. Two different ways. So he's just asserting, no, human law is derived from natural law. But then we have this problem that human law and natural law seem to come apart. There seems to be all this variability. It seems to be matters of indifference. Well, here's why none of those things are problems. Let me put your mind at ease. First, the first way that human law is derived from natural law is as a conclusion from premises. And secondly, by way of determination of certain generalities. The first way, he says, is like to that by which in sciences demonstrated conclusions are drawn from the principles. So there's a way in which human law is derived from natural law that is a lot like just running syllogisms or mathematical equations or geometric proofs. So if axiomatically A is true, and if A then B, and B is true, then A. Or if A then B, then B. Right? Or if we define A to be the equivalent to Y, and we plug Y into A, then if Y, then B. Whatever the logic leads us to, that conclusion is going to be true. Uniquely true. So if it's the case that good is to be done, evil is to be avoided, and if it's the case that human life is good, and human life is to be preserved, and its destruction is to be avoided. That's just logic. That's one way in which human law can be derived from natural. The second mode, he says, is likened to that whereby in arts, general forms are particularized. We might say settled, given specification, given specific conclusions or forms as to the details. Thus, he said, the craftsman needs to determine the general form of a house to some particular shape. The house needs doors. How tall are the doors going to be? We're going to have one door, we're going to have two doors. We're going to have double doors or single doors. Where are we going to put around the doors? Some things are therefore derived from the general principles of the natural law by way of conclusions. So this is the first way of deriving. That one must not kill may be derived as a conclusion from the principle that one should do harm to no man. Should I kill this guy? There's one uniquely right answer, and that is no. All other answers are wrong, according to natural law. While some are derived therefrom by way of determination. The law of nature has it that the evildoer should be punished, but that he be punished in this way or that way is the determination of the law. Determination is, to some degree, a matter of indifference. It's not indifferent that he be punished, but how he be punished, a particular sanction for that wrongdoing, is first a matter of indifference. I'll give a specification of that. Okay, so then when we get to Riggs versus Palmer, we find here a couple of different ideas of justice or law at work. We have a sort of sense that in general, it is universally true that one must not intentionally kill. And the court seems to think that logically derived from that, as a matter of logical deduction, no one who intentionally kills should benefit from his act of intentional killing. And that's universally true, no matter where you are, whether you're in New York or Persia or Greece or Turkey or London. And it's so obviously true and so uniquely true that the legislature of New York could not have intended otherwise. So even though there's no specific reference to, this is the majority reason, the dissent's going to disagree with this. The majority reason is that even though there's no specific reference in the statute of wills, New York statute of wills, to a murder prohibition, we should understand that prohibition on allowing someone to benefit from their act of intentional killing to be operative as a background principle of interpretation of the statute of wills, such that in the absence of any reference, express reference in the statute to a requirement or prohibition on killing, we should understand the principles of natural law to be in place, the legislature not having abolished. How many witnesses should there be? What sort of formal seal should there be made? How long should the testator have to renounce the will? All those are matters of indifference. And those are given specific form by the statute of wills. In this case, of course, all of those formal specifications of legal justice have been satisfied. Those aren't at issue. So the question is the requirement of natural justice still part of the statute of wills? Notwithstanding that the state legislature didn't say anything about it expressly. Okay. So that's the basic problem of the relationship between, call it, natural justice and legal justice, or natural law and human law, natural law and positive law. There are further complications taken up by Professors George and Green. So we look at Professor George's essay, Now Direction of the Natural Law. And so let's just assume for the sake of argument that Aristotle was right, and that natural justice and legal justice have to be considered on their own terms, both as parts of justice. And they operate as parts of justice in these different ways. And further, let's stipulate that Aquinas is right, that natural law is still law, or is still a principle from which at least some human laws can be and are derived direct, while other human laws are derived as matters of determinatio. And let's further stipulate, along with the majority in the New York Court of Appeals, that those derivations that are direct, logical implications of the principle of natural law are part of the law, unless and until the legislature specifies contrary to And then, even then, maybe they're still part of it. That's a question of legislative competence. Stipulate all of that. How do we get these principles of natural law into practice? How do we know what they require? Right? Because, okay, fine. Almost everyone agrees murder is wrong. What counts as murder? Is reckless indifference to human life, like the model penal code would have it, in the same category as killing with malice aforethought? Is in the same ballpark? And then there are lots of other things that people disagree about. So again, there's this problem of disagreement. People disagree about what the natural law requires. So isn't this an insuperable obstacle to Aquinas' argument? So Professor George is going to give us a very short summary of an argument that he's made, longer form in a number of different places. Moral norms here is more or less equivalent with natural law. So he's talking about conventional norms that are more or less derived directly from norms of critical grammar, principles of natural law, including those prohibiting evils such as murder, rape, torture, slavery, and genocide. He says they are what they purport to be. We're not fooling around here. But if they are what they purport to be, then there must be a point to abiding by it. That is, they have some rational basis. So the claim here is the direct determinations of natural law can be grasped by the exercise of reason. But human reason is capable of working these questions out and of critically evaluating the ways in which people have worked them out. Well, how does it work? It says the first thing you do is you look at the basic goods. You look at those reasons for acting that people have, which are not merely instrumental for some other ends, but which are valuable in and of themselves. Friendship is a basic good. And it provides reasons for performing a friendly act, visiting my friend in the hospital when he's sick, or taking a meal over to my friend's house, my friend contracts COVID. So I ask you, why did you bring that hot meal to your friend's house when he was sick? And you say, where's my friend? If I'm rational, if I'm sensible, that's going to satisfy. And it's okay, I get that. That makes sense to me. I get the point of your friendship. That's sufficient. I don't need to know whether there's an ulterior motive or something else. The point of studying mathematics is to acquire knowledge of the mathematical science. And that knowledge is a basic good. It's valuable in and of itself. Doesn't mean it's not also instrumentally valuable. For say, learning engineering, so you can go out and build bridges, so you can go out and, get across the river to destroy your enemy. Sure, fine. There might be other instrumental uses. But if I were to just ask you, why are you studying algebra? And you say, because I want to know what x is. That should make sense to me. If it's the case, then knowledge is a basic good. So these basic human goods are reasons for our acting. And they precede our desiring, our judging. In a sense, they precede our desiring, our judging, or our wanting to pursue them. They're independent of our assent to them. So in a sense, they're prior to our reason. But in a different sense, they are subsequent to our reason. Because the point of inquiring into these goods is we're trying to solve the practical problem. What am I to do? What state of affairs am I to bring about in the future, which is worthwhile pursuing? So when we're inquiring into the basic goods, we're inquiring into something that is not yet the case. I've not yet acquired knowledge of mathematics. I've not yet done the friendly act for my friend. And I want to know, is it worth doing this? Is it worth learning to play the piano? Is it worth coming to this seminar and studying about the relationship between property and justice? And if I'm reasoning, if it is the case that there are basic goods, and that knowledge is one of them, and that knowledge of justice is a form of that good, and if I'm reasoning correctly, I should say, it should be satisfying, it should be intelligible, it should be sufficient for me to say, having knowledge of justice in its relationship to law is worthy of pursuit, in and of itself, regardless of what other goods I may get out of it. Okay. So you might disagree with that. That might be a point that you want to challenge. But let's for the moment just stipulate that he's right about that. Then what? Well, then the next thing we have to understand is that these goods, these basic goods, are good in different ways. They are, to use his term, incommensurable, or irreducible, or irreducibly different forms of the good, or aspects of human well-being. Why is that important? Well, the reason that's important is because there is no state of affairs in which we get all of this good, everything that's good about this possible option, taking a meal to my friend, and everything that's good about this possible option, learning to play the piano. I choose. I choose to pursue the good of friendship, and that's a rational choice. Or I choose to spend my finite time learning to play the piano, also a rational choice. But there's no state of affairs in which I get all of the good of this in this choice plus something more. The radically different, incommensurable, irreducibly good goods. And so he says the variegated nature of human flourishing, the fact that the basic goods can be instantiated in an unlimited number of persons, in an unlimited number of ways, means that we must make choices. Of course, many of our choices, including some serious and even tragic ones, are choices between or among morally acceptable options. No moral norm narrows the possibilities to a single uniquely correct option. But moral norms often do exclude some possible options, sometimes even narrowing them to one. So the first implication is free choice. That's the first implication of the incommensurability of basic goods. I have to choose. Can't do everything. That's good. That's good. So I have to make choices about which goods I'm going to pursue. And those choices are not predetermined by some calculation of the net greatest good for the greatest number, or the net greatest good possible state of affairs. So all forms of consequentialism are irrational in that sense. That's the first indication. The second indication is all forms of consequentialism, whether it's utilitarianism or rule utilitarianism or whatever, are irrational in a different sense, and that is the ends do not justify the means. So if it's the case that the basic goods are incommensurable, and if it's the case that these things are good in and of themselves, they are always reasons for a choice in action. And that means that there are some things which you must never be willing to do. Ever. No matter what other goods you might achieve. It can never be morally permissible for me to kill Mr. Privet in order to save Mr. Grant. I'm sorry, Mr. Neal.
You're right about that.
Both Grant and me. 2 lives for the price of 1, right? I should be willing to do that, right? So if Peter Stan is right, if the consequences are right, I should be willing to kill Mr. Privet so I can save both Grant and me. Right? It contains multitudes. Yeah. Okay. Professor George is saying, no, that's not right. That's not correct. Because there's no state of affairs in which all of the good of Mr. Privet plus more is contained in the state of affairs in which Mr. Unity lives. The good of the life of Mr. Privet is radically incommensurable with the good of the life of Mr. Newton. And so it can't be rationally justified for me to intentionally destroy this life so that this life may be preserved. If it's possible for me to preserve Mr. Newton's life, of course I'm going to try to do that. But there may be circumstances in which I can't. I mean, these are the trolley and stretch hypotheses that I'm sure you're all familiar with. Mr. Neely's in one canyon, Mr. Privet's in the other canyon. Tracks go through the canyons. Trolley's going to head into one canyon unless I flip the switch to the other canyon. I'm going to decide where to flip the switch. It's an irrational question. I should never be willing to, in the words of Socrates, I should never be willing to be wrong with good news. That's the basic. So from that basic insight, that there are certain things which we must never be willing to do, we begin to get the first specifications of practical reason. There's an alternative to utilitarianism, in a sense, in the last part. At least for those who believe that ethical thinking proceeds from a concern for human well-being and employment. And that is what is sometimes called the natural law of ethics. Its first principle of moral judgment is that one ought to choose those options, and only those options that are compatible with the human good are considered integral. That is, in an open-hearted love of the good of human persons, considered in all of its varied dimensions. Now, the specifications of this abstract master principle are the familiar moral precepts that most people keep today seek to live by and to teach their children to respect, such as the golden rule, the Pauline principle, and Kant's categorical imperative. These are the principles of natural law, which we can straightforwardly apply, generally speaking, to practical problems that we confront on a daily basis. These are sufficient, without further specification, in many cases, to tell us what I should do and what I should not be able to do. If I ask, would I have this person do this unto me? And the answer is no, and I apply the golden rule, then the answer to the question, should I do this to the other person, is settled in one unique way. So we get sort of basic sort of boundaries or some specifications directly derived from the principle of natural law. Professor George's answer to the question, how does this direct derivation from natural law work? So then we have one final problem to confront, and it's that raised by Leslie Green, who's essay on moral positivism. I asked you to read just part 3 of the essay. Here he's going to talk about moral principles and the boundaries of law. So this is within, Green is making the case that we can understand law as purely conventional. He's going to give us the best case possible for the position which Aristotle dismissed out of him, that legal justice is merely a matter of convention. And in the course of making this argument, he's going to take on the 3 most prominent natural law thinkers of the 20th century: Juan Fuller, John Finnis, and Robert Taylor. So just walk through. He begins in the first paragraph here. Now, those of you who read the entire essay will be familiar with the sources thesis and the separability thesis. If you didn't read the entire essay, that's fine. Because I'm sure you remember this from Foundations of Law. The positivists have basically 2 basic theses about the law. One of them has to do with the validity of the law turning on its source. Right? So sovereignty or power makes a law valid. If you have a sovereign or a more powerful person, and that person issues a command, that command is law as to the person who's under the power of the sovereign. That's the sources thesis. If you want to know whether a law is valid, all you have to know is its source. And that's sufficient to determine the validity of the law. And then the other thesis, which is an entailment of the sources thesis, is known as the separability thesis. And you saw different versions of this in Foundation. You saw Bentham's version, which is a very robust almost moralistic version, right? And law and morality usually have nothing to do with each other, because morality is for brutes. We want a text, right? We want clarity. And then it's softened a little bit in Austin. Austin says, well, there is this thing called morality. It's sort of like fashion. It's entirely conventional. And it really has nothing to do with law. But it exists. And some people even believe that there's a God, and that's fine. That God can promulgate laws for them, but that's in a different domain. That's not real. And then Hart softens it in even a little bit more and says, I'm just going to be agnostic on the question of natural law. All I need to know to describe law is what are people doing in fact in their practical reasoning. The lawful driver stops at the stop sign because the law, the specification, you shall stop at stoplights, provides a reason for her action. And so Hart says that separability thesis is really just a descriptive thesis. That law as it is different from, not the same as. It's importantly different from law as it should be. And even you natural lawyers should embrace this. What do you want to do? You want to use critical morality, law as it should be, to critique positive law as it is. Well, the only way you can make a moral critique of positive law is if morals and law are different things. Else they just collapse into each other, and that's just different things. So that's hard separability. So Green picks up now, and now he's going to, so he's accepting the sources thesis and the separability thesis, and he said, now he's going to pick up and say, well, let's consider the strongest attempts to undermine the case for positivism. Three strongest are Finnis, Fuller, and Fuller. And he's very quickly going to go through Finnis and Fuller because he says, well, whatever they think about natural law, their idea of positive law is not incompatible with the sources and separability thesis. So he says, if one accepts, as Finnis does, that the existence and content of law can be identified without recourse to moral argument, and that, here he's quoting Finnis, human law is artifacted artifice, convention, to use Aristotles, and not a conclusion from moral premises. It becomes hard to see how the natural law theory develops rivals rather than accommodates the truth of the positive. And that's just true, isn't it? I mean, in that reading of the natural law theory, Aquinas is a legal positivist. Remember, Aquinas has a four-part definition of law. It's an ordinance of reason made by him who has care of the community for the common good and promulgated. And we can look into the fourth element and ask, is this promulgated? And the positivist can say, if it's promulgated, that's all we need to know. And Aquinas, in a sense, agrees with it, doesn't it? If it's promulgated, it is law. Now, Aquinas wants to go on and say, but it might be a defective law because it was not made for the common good, or it's not an ordinance of reason because it contradicts itself, or it wasn't promulgated by the proper authorities. Positivist says, but we've got Aquinas on our side. He distinguishes between human law and natural law. That's enough for us. He's not contradicting us. That's all we're saying. The question is that all Aquinas is saying? And is that all the positivists are saying? Are they really that compatible? Because that's his claim. This also initiates non-foolish criticism of Hart, Green says. He briefly talks about the rule of law principles, the 8 criteria of legal validity, which you recall from critical morality of law. Law is only law insofar as it produces order. What's the problem with King Rex? King Rex promulgates these laws which are arbitrary, which are retrospective, which are not clearly promulgated or articulated, which are not administered with consistency and so on. These are virtues of law, the failure to attain any of which is a failure to make law. And remember, this was the basis of Fuller's criticism of Hart's separability thesis. Fuller said, it follows then that law has morality in it. You can't separate it. There are certain virtues which law must exhibit, else it isn't even law. Green says, whatever virtues inhere in or follow from clear, consistent, prospective, and open practices, those are the virtues of the rule of law according to John Fuller, can be found not only in law, but in all other social practices, with those features, including custom and positive morality. So divine law and conventions and customs and fashions, they also can fail to guide practical reason in exactly the same ways. So what Fuller is identifying as features, necessary features of law, necessary virtues of lawfulness, are really just virtues or features of practical reason in general. There's nothing distinctly legal about them, or uniquely legal about them. Furthermore, Green says, such virtues, if they exist, are minor. There's little, if anything, to be said in favor of a clear, consistent perspective, public, impartially administered system of racial segregation, for example. This was Hart's criticism of Fuller's criticism of the Nazis. So the inner morality of law that Fuller identifies are relatively minor features of moral conduct. The real basis for critiquing the law as failed law are external to the law. That's Green's claim. The features which George identifies as the basic principle of practical reason. Dworkin requires a little bit more to deal with. He briefly summarizes Dworkin's theory. Theory of law is for Dworkin a theory of how cases ought to be decided. And remember, for Dworkin, the most important thing about law is that it has integrity. That every case is decided in a way that makes all of the cases consistent. And the cases, the determinations of judgment are rendered consistent according to some ideal political principle. Now, Dworkin's not a natural lawyer in the full-on Finnish George sense. He doesn't think that the political principle is a principle of natural justice in the Aristotelian sense. He thinks the political principle could be settled and specified in the original instance, ab initio, in a number of different ways. But once a political community has committed itself to, say, a principle of choosing, equality of equal respect for all persons, or a principle of, say, no deprivation of liberty without due process. Once they've chosen that principle, all cases, all legal disputes, cases, and controversies have to be decided consistent with that principle. Okay, so that's Dworkin's theory. Green says, once that principle is in place, that past political decision, this is going to be our ideal principle. Everything going forward has to be consistent with that idea. So if society has a legal system, it follows that. Society has a legal system only when and to the extent that it honors this ideal. And its law is the set of all considerations that the courts of such a society would be morally justified in applying, whether or not those considerations are determined by any source. To identify the law of a given society, we must always engage in moral and political argument. This is again Green summarizing Dworkin's argument. For the law is whatever requirements are consistent with an interpretation of its legal practices that shows them to be best justified in light of this culminating ideal. Whatever the ideal is, we have to be able to reconcile it with all of the particular decisions. Okay, Green says this is basically a form of cheating. Why? Because ultimately, Dworkin's theory doesn't depend upon the merits of the ideal itself. Remember, for Dworkin, in the original position, crossing the line between Dworkin and Wallace, but call it the original political agreement, the original political settlement of the ideal principle, the principle could be anything. And he's not saying the principle is a particular true determination of natural justice. It could have been anything. And so Green says it's the sources that make the merits relevant. So Dworkin's theory, Green charges, is ultimately parasitic upon positivism. For Dworkin, what matters is that it is the political community which is chosen. And so Dworkin's theory is really parasitic upon a sources thesis, which he doesn't identify, doesn't critically evaluate, and isn't particularly honest about. So we continue. To understand and assess this response, some clarifications are needed. First, it is not plausible to hold that the merits are relevant to a judicial decision only when the source is making so. It would be odd to think that justice is a reason for decision only because some source directs an official to decide justice. It is of the nature of justice that it properly bears on certain controversies. In legal decisions, especially important ones, moral and political considerations are present of their own authority. They do not need sources to propel them into action. On the contrary, we expect to see a source, statute, decision, or convention which judges are constrained not to appeal directly to the merits. So moral merits and legal sources are separate inquiries. Second, the fact that there is moral language in judicial decisions does not establish the presence of moral tests for law. For sources come in various guises. What sounds like moral reasoning in the courts is sometimes really source-based reasoning. For example, when the Supreme Court of Canada says that a publication is criminally obscene only if it is harmful, it is not applying J.S. Mill's harm principle. It's not appealing to natural justice. It's not actually using the term harm in a way that would be universally recognized throughout all human civilizations. It's using it as a particular term of art. It means that which is regarded by the community as degrading or intolerable, which is a specification of law. And so we need to look to the sources of that specification to determine whether that specification is valid. It's a source-based test, moral. And so it's just not the case, Green Weinstein says, that laws are or can be derived more or less directly from the first principles of practical reason. Just not the case. Aquinas, and if that's what Aquinas and Professor George are claiming, they're just wrong. The validity of the law depends upon its source. Who promulgated it? Does that person in fact have the power to do the promulgation? That's the inquiry. The validity of the law does not depend at all upon its whether it comports with principles of practical reason, no matter how direct their purported definition, their purported derivation from first principles is supposed to be. Okay, we get the basic contours of the disagreements and issues here. Another set of cases that might be helpful to think through some of this stuff is the spite cases. Think about the spite cases, the Keeble versus Hickeringill, the spite fence cases. Here's another set of cases where there's no positive enactment which says that the intention of the allegedly offending landowner is relevant to determine whether the action is for which law will provide a remedy. Right? Is this actionable or not? If the source's thesis is correct, then we should just be able to identify a valid source for this law, and that should determine what the rule of the case is. Green insists that's true whether or not the further claims that Hart makes about secondary rules is true. Right? The source's thesis doesn't necessarily logically entail a particular theory of rule of recognition. You could identify sources in a number of different ways. Right? Hart says as a rule of recognition, that's the most common way to go about identifying sources. That's what we want. That's what we're about. But that's not what the court said in the spite cases. Right? That's not what they say. They say that to act with no intention to benefit oneself, but only to cause harm to one's neighbor, is to perform an inherent wrong, to do something that is contrary to natural justice. And to do an inherent wrong cannot be part of one's powers, legal powers, as a property owner. Despite cases in the American tradition anyway, and in Keeble, are very strongly on the side of Aristotle and Aquinas and George. Interestingly, in the English tradition, the English almost always completely ignore Keeble and always cite Bradford versus Pickles, which says intention is irrelevant. If you're using your property, using your land in a way that does not offend any particularly identifiable positive law declared by the sovereign and promulgated, you're free to do that no matter what your motivations are, even if your purpose in putting up that ugly fence is merely to cause harm to your neighbor. So the English approach is spite is irrelevant. See, what's the agreement? Okay, so what do we think about this?
For more understanding of law, rights, and each other, see my new book, The Age of Selfies, Reasoning About Rights When the Stakes Are Personal. And visit my website, www.adamjmcleod.com.